What's being done about gerrymandered maps?
So there are a couple of different things that are being done. One is that there are a number of challenges to partisan gerrymandering that are moving their way through the courts, both federal courts and in one instance in a state court. Likewise, there are very robust reform efforts that are going on around the country, including in Michigan, where people are trying to take control of the process and have a fair map drawing process. So I can talk about either or both, or in whichever order you want.
How about we talk about the court challenges first? Because I know the Brennan Center and you personally have been very involved in those.
Sure. So there are two partisan gerrymandering cases at the Supreme Court currently. I should actually say three, but there are two that are being argued this term. The third is on hold. One out of Wisconsin, which involves a Republican gerrymander of the legislative map there, and the other is a case out of Maryland involving a Democratic gerrymander of the congressional map. And the Supreme Court heard argument in the Wisconsin case in October, in the Maryland case at the end of March, and it's expected to issue a ruling by the end of June. It probably will likely come out the last week in June. These are very complicated, hard cases, and the court, this is an issue that the court has long sort of wrestled with. And while the court has long recognized that partisan gerrymandering is anathema to the Constitution and that it's not good and it's not good for democracy, where they've deadlocked is on actually defining the standards that would enable courts to police it. And the last time the court considered the issue in a big way in 2004 in a case called Veith, the court deadlocked really badly with four of the justices saying this was an issue that they thought was so political that courts shouldn't even consider it. Another of the four justices, the liberal justices of the day, saying that the Pennsylvania map should be struck down, but not agreeing on a standard. In fact, they came up with three different standards. And then Justice Kennedy, in his very familiar role in the middle, saying that he didn't think that the Pennsylvania map was unconstitutional, but he wasn't also willing to step away from the issue for all time. And he proposed yet a fourth standard. And so, that's really where things have been left in the decade since. And a lot of lawmakers took the failure of the Supreme Court in Veith to resolve the issue, and then a second time, a couple of years later, in a case out of Texas called Lulek versus Perry, they have taken the court's failure to come up with to enunciate a standard in those two cases as a green light to do whatever they want. And you've seen that this decade in places like North Carolina, where the map was struck down for racial discrimination, for being a racial gerrymander, and the legislature in North Carolina was ordered to redraw the congressional map. The lawmakers came back and they said on the record, on the floor, well, if we can't do a racial gerrymander, we're going to do a political gerrymander, and that's okay because that's not against the law. And that's probably the most brazen example of people willing just to sort of put their politics on the table. But you've seen that in other places as well. You saw that you've seen it in Texas, where lawmakers have defended very discriminatory maps on the basis that they weren't trying to discriminate against Latinos and African Americans. They were just trying to discriminate against Democrats, and likewise. So, the failure of the Supreme Court to come up and articulate a standard against excessive partisanship in the way that they have, or said that discriminating on the basis of race is wrong, or that drawing districts with too much consideration of race is wrong. They now have a chance to also say something about partisanship. We will see what they say. I think the people in the field are very optimistic that the court recognizes that partisan gerrymandering is a significant problem, that it's one that they need to address, and that they recognize their role in making gerrymandering worse. But exactly how far they're willing to go, it remains to be seen. I think there are two principal challenges for the court. On the one hand, they want to have a robust enough standard that it actually picks up enough of the problem. At the same time, they don't want to sort of get involved in every single city council redistricting, right? And they think that that's too much. And so, they want to be able to have something that's clear enough that it provides guidance that these sorts of things are out of bounds. These are okay, and that there might be a little bit of a gray area, but just a little bit of a gray area. And so that's the challenge for the court. And they've had a robust number of a robust menu of options laid out before it, and we'll see where they go.
What are the plaintiffs in the Wisconsin case and the Maryland case seeking in terms of remedy or standard that they want the court to apply?
So there are two very different standards at issue in the two cases, the court, even, and there are more that are laid out on the table by other people. But what the people in the Wisconsin case have done, the plaintiffs in the Wisconsin case have done, is they framed the challenge in terms of a statewide. Well, what the Wisconsin plaintiffs have done is that they framed their challenge as a statewide challenge to the map as a whole, and they've argued that Republicans in Wisconsin have a disproportionate share of seats, and in other words, that the map is biased in favor of Republicans, and that bias is durable. In other words, that it's something that can't be corrected just through ordinary politics because the maps are so artfully designed that they stick. And so, the issue really is intent. Did you intend to favor one party over the other? Did you create this? Do the maps, in fact, favor one party over the other durably? And is there some kind of excuse that justifies it? In other words, you could have bias in a map because of, the Democrats that live in the cities, or you're trying to comply with the Voting Rights Act, or any number of what we would consider legitimate neutral reasons. So the state gets a chance to sort of defend its maps under the Wisconsin theory. And so that's the Wisconsin case. Then in the Maryland case, the argument is that Democratic lawmakers in Maryland retaliated against Republican voters in the old Maryland 6th congressional district because they weren't happy with sort of the way that they were voting, and moved them out of the district and moved other people in. And as a result, you created a safe Democratic district. And so that one, unlike the Wisconsin case, is a district-specific challenge based on things that happened at the district level. Whereas Wisconsin is a statewide challenge looking at the map as a whole and asking whether parties received a fair share of a fair allocation of seats, and whether the map is responsive to electoral swings.
So how in Wisconsin is the court supposed to determine whether those maps are unconstitutional or not?
Well, that's a great question, because there's been a lot of talk about sort of like various social science metrics and things like that, and an easier way to think about it is, the question is one of intent, right? You have to sort of prove intent, and just like in all kinds of cases, there are lots of ways to prove intent through lots of different kinds of evidence. And so an analogy I often use is if you go to the doctor and you say, "Doctor, I think I may have cancer," the doctor is likely to ask you about your symptoms. The doctor is going to ask you about your family medical history. The doctor is going to conduct a physical exam. But the doctor also probably is going to send you for some blood work or an MRI or other sorts of tests. And it's that combination of things that enable the doctor to sort of make an informed call as to whether you have cancer or you don't, or whether you need to have some kind of exploratory surgery or not. And it's similar in the redistricting context in the sense that there are lots of flags that you can have. And so, for example, in North Carolina, the evidence is really clear, right? The lawmaker said on the record, "We are doing a partisan gerrymander." So, like, you don't probably need a lot more evidence. That would be the equivalent of going in and, like having a really clear sign that you have cancer, right? You don't actually need to do more. In other cases, it's a little bit harder, right? And you have to rely on evidence like statistical measures or the shapes of districts or things like that in order to get at whether there is likely intent. And the good news is that we have all of these statistical measures now that people can apply. And, they don't have to apply one. There are literally dozens of them, and they can apply all of them and sort of get a sense of whether they point in the same direction or not, or whether they raise red flags. One of those is the efficiency gap, which was used in the Wisconsin case, but there are others: the mean median difference, the seats to votes curve. People have drawn hypothetical maps to determine whether the map is an outlier or not. And so there are lots of ways that you could do that. And again, none of these tests put a map conclusively out of bounds. A map could still be fine, but what they do is they flag that you might need to look more closely. So it's the equivalent of, if I'm getting up in the middle of the night and having to use a bathroom a lot, it might mean that I have diabetes, or it might just mean that I drink water too late before I go to bed, or I have a small bladder, or whatever the case may be. And so and likewise, a map that just because it has a high efficiency gap or something isn't necessarily out of bounds. But what these statistical measures do is they enable courts and lawmakers and others to say, wait, we should take a closer look, because there seems to be something that we're getting at least a yellow flag here, and we should look more closely. And all of that comes together. And is helps the court decide whether there's intent. A lot of times people will say this is really hard, but this is not any different than what we do in sex discrimination cases or securities fraud cases. Sometimes you have direct evidence, sometimes you have circumstantial evidence, sometimes you have eyewitness testimony and emails. Sometimes you have to rely on the fact that no women have ever been promoted, even though lots of women have applied, or and so courts are well suited and well situated to do this, because these are the sorts of factual findings that they make every single day.
Thanks. So what would be the result, let's say, if the plaintiffs were to prevail in the Wisconsin case? Does that put an end to gerrymandering, political gerrymandering?
Doesn't. It takes a big bite out of it, and it sort of creates some political hazard that may make it less likely that people gerrymander in the future, because now people know that if you go too far, at least, if you are too extreme, that there is a wall that you will run into, and you're going to have to turn over your emails and sit for depositions and do all kinds of things like that. And that may take some of the incentive to do gerrymandering out. But it probably doesn't end all gerrymandering, and for two reasons. One is what the Supreme Court is concerned about really is extreme gerrymandering, these sort of like the worst of the maps, and there's a lot of gerrymandering and a lot of sort of politics that go in that wouldn't be covered necessarily by that. Likewise, while there is this political hazard that I talked about, there's also an incentive for a party in control to sort of try to gerrymander, and because litigation takes a long time, it can take, in Texas, litigation started in 2011, is still going on today, 7 years later. And so, you can get a free election or two or three out of it until a court strikes down the map. And so, it probably means that, at least in some places, lawmakers will still try to go to town, and if they get struck down, that they were where they would have been otherwise. And if they get a free election or two or three, all the better. So it doesn't end gerrymandering, but it would set some important limits, it's important to, the limits that it would set are very important, especially from the standpoint of racial fairness, because in the places like the South this decade, you've seen people defend maps that are discriminatory against African Americans and Latinos on the grounds that they weren't trying to discriminate against African Americans or Latinos. They were just trying to discriminate against Democrats. And so, the sort of difficult race politics conundrum that the courts have created would be eliminated, and it'd be much easier to ensure fairness for communities of color. So limits on partisan gerrymandering would go far, but they wouldn't end the problem.
Okay. So what would end the problem?
Well, a good way to end the problem would be redistricting commissions or other redistricting reforms. And these, we've also studied that, and the reality is that you only have this problem of extreme gerrymandering for the most part when one party is in control of the whole of the process, and that means in most states that one party controls the legislature and also has the governorship, because the governor can veto a redistricting plan in most states. And so where you have this sort of one-party trifecta, people are able to go to town and create these sort of extreme gerrymanders. A easy way to fix this is simply to make sure that everybody is at the table. Democrats and Republicans, and in places like California that have created commissions, they've also added independents who are in a big and important bloc who currently aren't at the table, and making sure that each party effectively has a veto over the process by itself, regardless of anything else, sort of creates a much fairer process, because you're not going to get a situation where, for example, in California, the Democrats on the commission propose a map that screws Republicans, and if the Republicans have a veto on that, presumably they're not going to say, yeah, that's fine, right? And so, simply making sure that everybody has a seat at the table through an independent commission or through rules in the legislature that require a supermajority, including minimum support from the minority party, goes a really long way in making the process better. Other things that are really key are making sure that there's public participation and transparency, and the like, and so these are all reforms that go a long way to helping create a more inclusive and better process.
So in terms of these commissions, here in Michigan, we've heard a lot of skeptics say, well, that's really not going to solve the problem. Have you studied the maps that have come out of the California Commission, for example, or the Arizona Commission? And have you seen whether this process actually works and whether it has prevented gerrymandering in those states?
Yes, we studied both Arizona and California, and California was a really particularly big test because up until then, Arizona is a diverse state, but it's a relatively small state. California is a large, very demographically complicated state. It's got multiple cities, it's got multiple ethnic groups. It's very fast changing. And so, there always been a question of whether you could do a redistricting commission in a state that is large and complicated, and particularly if you're taking power out of the hands of lawmakers and giving it to everyday citizens. And there was this really strong belief among the political class that everyday citizens weren't well situated that they wouldn't be up to the task because what they didn't understand all of the political dynamics and whatnot, and that they would be they would draw bad maps in effect. And that has proven not to be the case. The California Commission, the commissioners, by almost every measure did an extraordinary job. And even people who were a little bit worried about the commission have come back and said that, they think the commission did well in drawing maps that are responsive to people's concerns. Now, that's not to say that everyone is happy completely with every single decision. That's life. But they seem to think that the commission as a whole made reasonable choices among the range of reasonable choices. And so on one particular measure, sort of whether maps are electorally responsive or not, both California and Arizona have done exceptionally well, and in California even more so than Arizona. In California, as Republicans or Democrats win more votes, they win more seats, and so there's a lot of flexibility in the map, at every level from, and so there's a lot of incentive to compete wherever the electorate is, and so that has been a really great thing that we found, and that's completely different than what California had before, because the last set of maps that California had before they created the commission, it was a bipartisan gerrymander where Democrats and Republicans got together and they basically said, you keep your seats, Democrats, and we'll keep our seats as Republicans, and as a result, no seats were competitive. That's complete contrast to the maps in California today, where there's a lot of competition. In fact, if Congress changes hands this election, a large part of it likely will be due to seats in California in places like Orange County, where there's just a lot of competition. It's really quite extraordinary. And I should say, in California, the commission was not charged with drawing competitive maps. In fact, they were expressly prohibited from considering political consequences. What they were charged with is keeping communities of interest together and keeping towns and other sorts of things whole. And it turns out that when you do that in a state like California, even a fairly blue state like California, um, you end up with a lot of natural competition. And instead of having districts that stretch 200 miles up the coast along a highway, you have neighborhood-based districts that have done better for letting women and people of color and other first-time candidates run, and that are robustly competitive. And that's exactly what people think that democracy should look like.
Great. So we've talked about lawsuits where you can challenge a set of maps on a statewide basis or per district. And we've talked about these independent commissions, which in California and Arizona, they were the product of a voter-led initiative. But not all states allow those, a direct democracy like that. So what are some of the other sort of fixes that you have studied or seen to work in some of the other states?
Sure. So you're absolutely right that the most robust reforms have come as a result of ballot initiatives. And, and that's when people go directly to the voters and are able to sidestep the legislature and create reforms. Lawmakers, not surprisingly, are very hesitant to give up power. But that's not to say that there aren't things that could be done. And, for example, in Ohio, the legislature passed a reform where you have to have a supermajority now to pass a map, and you have to have minimum levels of support from the minority party, whether that's Democrats or Republicans, in order to pass a map. And if you can't get that kind of supermajority and the required minimum level of support, any map that you pass, there's a strict provision that prohibits favoring a political party or incumbent. And so that's a huge protection that can be done even if you leave power in the hands of a legislature. Other things that you could do is you could create an advisory commission that could draw maps. And so that's another reform that can be done. That can sometimes be a little bit more politically palatable to lawmakers who worry that the commission is going to create really bad maps or draw them out of a district or something like that. But nonetheless, you can have a fairer, more inclusive process that way. So those are a couple of things that can be done. The last thing I will add is that at least at the congressional level, it's also something that Congress could fix. If probably not this Congress, because this Congress has trouble doing a lot of things, but a future Congress has power under the Elections Clause to mandate how congressional redistricting is done. So reforms also could come at the congressional level if you had sort of the right Congress and the right sort of political environment. And so there have been bills proposed at the national level that would require every state to use a redistricting commission or impose a more uniform set of criteria.
Well, it's encouraging to know that there are different options available. Thank you, Michael.
Thank you.